He walks into a Michigan courtroom facing a felony that could put him away for 5 years. And instead of a lawyer, he brings a legal theory nobody in that room is going to accept. Within seconds, he's not arguing about the charge. He's arguing about the authority of the court itself. This is one of those hearings where you can feel the temperature rise in real time. On one side, a judge with decades of procedure behind him, trying to run a routine arraignment. On the other, a defendant who declares himself the executive of a private trust, claims indigenous sovereignty over the literal courtroom, and tells the judge that state law is a matter of perspective. If you've spent any time in the world of courtroom footage, you already know where this is going, because this is a textbook example of what's often called a sovereign citizen defense. It almost never works. But watching it unfold live, watching a judge calmly dismantle every claim while still trying to protect this man's due process rights, is genuinely one of the more fascinating exchanges you'll see in a courtroom this year. By the end, we're not just talking about a fleeing and eluding charge anymore. We're talking about a competency evaluation, a missed filing deadline, and a judge who's clearly done letting the defendant set the terms. Stick around, because the moment where the judge draws the line on whose rules get followed, that's the clip everyone's going to be talking about.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect. That's not the way it works. You don't get to make the rules. I'm ordering a competency.
It's against my religion to adhere or to assimilate to any statutory.
As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. And man, you're going to figure out something. We're playing by my rules, not yours. So you do not say anything because you're going to figure that out real soon. I said you can go.
I am Tariq Maratari-Kade, the executor of the Tariq Maratari-Kade Living Trust and the registered owner of the Tariq Maratari-Kade Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this.
Let's pause here, because this is the crux of the entire hearing. The defendant is invoking what's sometimes called the sovereign citizen argument. The idea that if you declare yourself outside the jurisdiction of state or federal law, the court simply loses authority over you. Courts have rejected this theory consistently across nearly every US jurisdiction for decades. It doesn't matter how it's phrased: indigenous sovereignty, common law trusts, assimilation objections. None of it changes the fact that a Michigan district court has jurisdiction over conduct that happens on Michigan roads. What's notable here is how the judge responds. He doesn't get rattled, and he doesn't dismiss the defendant outright either. He keeps circling back to a simple, almost clinical question. Do you understand? That question is doing a lot of legal work. It's the judge building a record, protecting the proceeding from appeal, and, as we're about to see, starting to lay the groundwork for something much bigger than a traffic stop. Do you think the judge is being patient here, or is he already several steps ahead of the defendant? Drop your take in the comments.
In this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm
And there it is.
having a hard time understanding why.
Point of the entire hearing. A competency evaluation isn't a punishment. It's a safeguard built into the system to make sure a defendant actually understands the proceedings against them before those proceedings can move forward. Given everything we just heard, the refusal to acknowledge basic jurisdiction, the repeated "I do not understand" responses to straightforward questions, it's not hard to see why the judge felt this was necessary. But here's the twist that makes this moment so tense. The defendant tries to negotiate the terms of his own competency evaluation, essentially asking the prosecution and the court to agree to it like it's a settlement. The judge's response is almost instant, flat, unbothered, and final. That's simply not how any of this works. It's a small moment, but it tells you everything about the power dynamic in that room. Who do you think comes out of that forensic evaluation the way they expect to?
Or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an indigenous person.
No,
So
sir, what you're about to state is incorrect.
well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
We're
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers, agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time?
9 a.m.
At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, yeah, I mean, is this, uh, what are, excuse me, what are you relaying to in regard, what are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
With the court, ask the people to prepare the order for the conference.
Yes, please prepare the order for this. Is that your address, sir?
Excuse me? That's correct.
All right, very good.
I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did, I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
So where does that leave us? A defendant facing a third-degree fleeing and eluding felony, up to 5 years, a possible $1,000 fine, and a year-long license suspension, walks into arraignment armed not with a defense attorney, but with sovereign citizen arguments about indigenous land and religious exemption from state law. None of it holds. The judge, methodically and without losing his composure, walks through the defendant's rights, confirms he doesn't understand the proceedings well enough to confidently move forward, and orders a forensic competency evaluation, setting a hearing for July 25th. Along the way, a motion the defendant claims to have filed goes conveniently missing from the record, and the judge makes it unmistakably clear whose courtroom this is. The broader takeaway: sovereign citizen legal theories have a near-perfect track record of failing. Courts have addressed and rejected these arguments over and over, and this hearing is a case study in exactly why. Procedure doesn't bend because a defendant declares it doesn't apply to them,